Good afternoon. I want to welcome you to our presentation today regarding writing contracts for a post-COVID world. My name is Tom Urban, and I'm a member of the telecommunications, media, and technology law firm of Fletcher, Hildreth. This is just one of the many informative webinars and presentations that can be found on our blog, and that's up on the screen, www.comlawblog.com. If you want more information about our firm or any of its attorneys, you can find that at the website, www.fhhlaw.com. We could go to the next screen. Today we're going to discuss several topics within the subject area. We're going to start with the COVID-19 effects on litigation, and then we're going to discuss various contract doctrines that are applicable, especially in the COVID-19 world. They include force majeure, impossibility, and frustration of purpose. And we'll be talking about several cases that have interpreted those kinds of provisions, especially the force majeure clauses in contracts. Then we'll go on to potential impacts of the COVID-19 moving forward and make suggestions about how you can negotiate contracts to address the potential not only of future pandemics, but other unexpected events. We will have a question and answer period at the end of the presentation, but I encourage you to type up any questions you may have as we go along. There's a pull down on the right side of your screen where you can type in questions, and I'll be on the lookout and try to answer them as we go along. If we could go to the next screen. As we all know, the COVID pandemic has had a profound effect on all of our lives. For us civil litigators, it has also had an enormous effect on the ability to move cases through the judicial process. The civil case backlog may take years to overcome, especially given that civil cases have to allow precedence for criminal cases. So all courts are having to handle the criminal cases that are backing up before they start having civil jury trials. Also, we've noticed that there have been substantial challenges to various COVID-19 legislation, which is also causing delays in the court system. Substantively, the pandemic has caused litigants in courts to evaluate the application of various traditional common law principles and existing statutes to the conditions caused by COVID-19, such as restrictions on business openings, requirements that people work from home, and slowdowns in the availability of various products, in economic terms called supply disruptions. Moreover, the pandemic has led to legislation at both the federal and state levels, which has had a substantial effect on the lives of all Americans and does not show any sign of dissipating under the new federal Biden-Harris administration. We could go to the next page. Due to the various restrictions necessary to combat the pandemic, it has become difficult, if not impossible, for many parties to contracts to be able to honor the terms of those contracts. As a result, these contracts have not been able to be fulfilled. The question then becomes, which party to the contract will have to bear the loss of failure to perform under the contract? Should it be the non-performing party or the party who is relying upon performance? These issues arise in a wide variety of contracts. We've got some of them listed there. Obviously, contracts for goods and services, commercial and residential leases, advertising contracts, and I'd even add insurance contracts to this list, which has been a source of a lot of litigation. There are various potential contract doctrines which may govern these matters, depending on the jurisdiction in which the contract was made or in which the contract calls for interpretation of the contract. Now, many contracts have a provision that calls out the state for which the law will be applied to that contract. But in absence of that type of provision, states have conflicts laws that govern which state's law will apply to a contract. For example, in Virginia, Virginia courts will apply the law of the state in which the contract was finalized, and usually where the last signature was made on the contract. Other states look at the various contacts that different states have to the contract and look at the substantial contacts that each state may have. So, for example, in California, if you're going to be performing the contract primarily in California, they would apply California law. The doctrines that affect who will be responsible for the risk of loss include force majeure, impossibility, and frustration of purpose. But each of these doctrines is reliant upon the manner in which they'll be interpreted, which depends on the various laws of the states for interpretation. Moreover, some contracts have been affected by local, state, and federal legislation that was passed in response to the pandemic. In addition, the remedies available to parties to contracts for which any of these doctrines, statutes, and case law may apply vary by state. In all cases, the first and most important thing to review is the language of the contract. This was brought to the fore in a case that was just decided last week by the U.S. District Court for the Southern District of New York. A student at NYU had sued NYU demanding a partial return of their tuition because classes were not conducted in person. The court looked at the various documents that comprised the contract in that case, which would be the university's catalog, any brochures that were submitted to students to encourage them to attend NYU, and based upon those documents that had been presented by both sides, the court found no specific promise anywhere in those documents that classes would be conducted in person. As a result, the court dismissed the case, but gave the plaintiff an opportunity, if they found additional documents, to amend their complaint if necessary. Let's now go to the next slide. The first contract doctrine we're going to talk about is force majeure. Force majeure is an unexpected and disruptive event operating to excuse a party from a contract. Now, most force majeure applications are based upon language that is specifically in the contract, as opposed to the other two doctrines, which are case-developed contracts by doctrines by courts on how to interpret contracts. The application of this doctrine is very dependent on the jurisdiction in which the contract is being interpreted. For example, in Virginia, force majeure clauses are strictly construed and limited to the specific terms of the contract and the specific events described in the force majeure clause in the contract. On the other hand, California takes a more liberal approach to interpreting force majeure clauses, and Louisiana, which is a civil law state, has a code provision that applies the force majeure doctrine to all contracts that are interpreted under Louisiana law. The key to force majeure cases is the specific language of the force majeure clause and whether the loss would be foreseeable. In other words, whether the parties to the contract could have reasonably foreseen the event that impeded performance under the contract. Now, in the COVID-19 context, the choice of law jurisdiction can have a profound effect on the application of the doctrine. While a court in one state may require that the applicable clause specifically mention that the provision applies when there's a disease or pandemic to trigger the clause, another state may consider a reference to government action or acts of God or natural disasters as being sufficient to invoke the provision as a defense to a breach of contract case. One thing to remember is that in the COVID world, there's been many government actions that required restaurants to close, businesses to close, but in order to trigger the force majeure clause, unless it has some side provision about a partial closure, it would require a full closure. So often these clauses do not apply for restaurants if they're allowed to have limited seating or if they would be able to have carry out or delivery, because they can still do business. Now, that gets us to one of our first cases, and let's go to the next slide, the Chuck E. Cheese case. In this case from the Southern District of Texas, Chuck E. Cheese tried to sue landlords in 3 states, North Carolina, Washington, and California, to get out of paying rent for its restaurants. Now, for those of you who have young children, you know that Chuck E. Cheese is not really a restaurant. It's an arcade where children play games, and the restaurant is sort of ancillary to the enterprise. It's sort of like, concession stands at a baseball game. Nobody goes to the concession stands when the baseball game's not going on. Similarly, almost nobody goes to a Chuck E. Cheese's just to eat dinner. So the argument that Chuck E. Cheese made was these 3 states had prohibited any games to be played by children for a substantial period of time. As a result, they lost Chuck E. Cheese's lost substantial revenue and ended up going into bankruptcy. To try to avoid the rental payments, Chuck E. Cheese's asserted a force majeure argument based upon the force majeure clauses from the various leases. Now, as you can see here, actually each of these force majeure clauses was slightly different, but this is the force majeure clause from the North Carolina lease. And it says, subject to the casualty and condemnation provisions of this lease, if either party shall be prevented or delayed from punctually performing any obligations or satisfying any condition under this lease. And I'm not going to go through all the various events that are discussed, but they include acts of God and unusual government restrictions. But if you look at the very end of this provision, it says this section shall not apply to the inability to pay any sum of money due hereunder, or the failure to perform any other obligation due to the lack of money or inability to raise capital or borrow for any purpose. Now, the court in this case, the Southern District of Texas, found that it was possible that the COVID-19 pandemic might be an act of God, or the response to it might be an unusual government restriction, regulation, or control. But the problem was that this provision at the end excluded rental payments from application of this provision. So as a result, the court found that Chuck E. Cheese's still had to pay rent under this provision. Now let's go to the next screen, because that one has, oh, all right, and this is a second version of the Chuck E. Cheese lease that was more direct, where it talked about excluding rents, charges, or other sums reserved hereunder. That one was a less difficult decision for the court. Let's go to the next case. All right, so this is a force majeure provision from a contract between an art auction and an owner of some art that was being put up for auction. And the contract called for the art to be put up for auction by a date certain, but it had this provision: in the event that the auction is postponed for circumstances beyond our or your reasonable control, including without limitation as a result of a natural disaster and many other events, in such event, our obligation to make payment of the guaranteed minimum shall be not null and void, and we shall have no liability to you. The contract called for a guaranteed minimum to be paid if the auction did not either occur by the date certain, or it did not raise substantial or beyond the guaranteed minimum. The art owner sued the auction house, claiming that the auction did not occur. It was scheduled for sometime in March of 2020, and the auctioneer defended based on the fact that all businesses in New York had been closed during that period of time. The court found that the COVID-19 pandemic was a natural disaster, and that the last part of the provision made the auction house not liable for the guaranteed minimum. Let's go to the next slide. Earlier we talked about the various statutory enactments that define force majeure. This is from the Virginia Code, section 15.2-2108-19, and this governs cable system providers. And what it says is that force majeure means an event or events reasonably beyond the ability of the cable operator to anticipate and control. It includes acts of God, and it specifically talks about epidemics. In Virginia, that's key, because acts of God, natural disasters might not necessarily be sufficient for application of this force majeure provision, but epidemics, I think, would squarely apply to COVID-19 pandemic. In addition to Virginia's regulation of cable system providers, for which this applies, the federal acquisition regulations, section 52.24914, has a force majeure provision that applies to government contracts. So again, when you're looking at looking back at contracts, whether they would apply, you need to look at whether there may be a statutory force majeure provision that might apply to the contract. All right, let's go to our next doctrine, which is the doctrine of impossibility. If you can turn the page. All right, the doctrine of impossibility occurs when a party to a contract is relieved of their duty to perform when performance has become impossible or impracticable through no fault of the non-performing party. In the COVID-19 realm, this would apply to forced restaurant closures by state and local governments. But again, you've got to be careful, what is the contract for, and is it impossible to perform that contract under the restrictions by the government entity? It's quite possible that if the government entity allows partial openings, limited staff, or delivery and pickup, that would overcome the application of this impossibility doctrine. Now, traditionally, this doctrine has been used in the following type of case. Let's say that Joe has a house and he contracts with me to paint that house for $5,000. Unfortunately, the day after we sign that contract, Joe's house burns down. If that occurs, then there's nothing for me to paint. And so therefore I cannot demand the $5,000 payment because of impossibility. It's impossible for me to paint a house that doesn't exist anymore. Similarly, these have been seen in contracts involving producers of produce. If I own a grove of Granny Smith apple trees and I contract with a buyer to buy my entire allotment of Granny Smith apples at the end of the season for $1 million, and then there's some blight that kills all my Granny Smith apple trees, then it's impossible for me to perform. So I'm relieved of my obligation of performance. The buyer is relieved of their obligation to pay me the $1 million. This has not been used in too many cases that have been decided yet, but I would imagine that it will be set forth in upcoming cases because of the slowdowns in the backlog on civil cases. The number of reported cases in general is quite small on the application of these doctrines to COVID-19. I think we'll be seeing more in the months moving forward, especially as courts start opening up more. If we can turn to the next page, we'll talk about our third doctrine, which is the doctrine of frustration of purpose. This is a doctrine that applies when a promissory is excused in certain situations when the objective of the contract has been defeated by circumstances arising after the formation of the contract through reasons beyond the party's control. And all of those elements in what I've just discussed have to be present for the application of frustration of purpose. As a result, this is the least likely of the three options because it's a very narrow exception to the requirement of performance. The quintessential case that we learned about in law school involving frustration of purpose was a case called Krell versus Henry from England. In that case, a gentleman had gone to a owner of a room that overlooked the main boulevard in London and wanted to rent that room so that he could watch the coronation parade of the king go by. The person who owned the room knew that that was the purpose for which the renter was wanting to rent the room, and Unfortunately, the king took ill, and there was no coronation of that king, and thus no parade. The owner of the room nonetheless sued, demanding payment for the room. And the court determined that since the owner of the room knew that the purpose for which the renter was renting the room was solely for the coronation parade, and as a result, probably the renter paid a substantial premium over what he would have normally paid for the room, that the court would not require payment in that case. These frustration of purpose cases require that a state actually acknowledge this doctrine. Many states do not acknowledge the doctrine or necessarily apply it very liberally. The courts tend to frown upon these kinds of cases because they think that these are the kinds of things that should have been considered when negotiating the contract. Okay. Let's go to the next slide. No matter which of these doctrines are asserted, each may be subject to remedies which are more limited than merely invalidating the contract. Depending on the circumstances of the effect of the pandemic or any other unforeseen event to the contract, the relief that may be provided may be limited to excuse delay in performance or monetary relief in the form of set-offs for any breach. For example, in the auction case, had the parties not come to an impasse, it would have been possible that that auction could have taken place once the government restrictions had been lifted. Each of these doctrines have varying application to a wide range of contracts for which an experienced litigator can evaluate based on the specific contracts and the facts at issue in any dispute. So let's talk about potential impacts of COVID-19 moving forward. Well, there have been quite a few cases recently in the insurance coverage realm. A series of professional sport teams, including the Philadelphia Eagles, the Sacramento Kings, and the Los Angeles Lakers, have filed suit against their respective insurers, seeking millions in coverage for pandemic-related losses because they were forced to cancel games. In addition, the owner of Seattle's iconic Space Needle has alleged in a federal suit that its insurer must cover business interruption losses tied to the coronavirus pandemic and related government shutdown orders under the tourist attractions $160 million policy. Now, a number of restaurants have also sued, as we saw Chuck E. Cheese's. That was a landlord case, but they've also sued their insurers. So far, most of the cases that have been decided involving restaurants and insurers or any of these insureds have actually been found in the favor of the insurers. That's likely because the insurers themselves are the ones who create the contract, and they make sure that there are provisions that allow them to limit the application of these business interruption clauses as much as possible. Other potential impacts of COVID-19 moving forward are rental evictions and student loan repayment. That's very much becoming an issue now that various legislatures that had prohibited evictions are letting those laws lapse. And so people who haven't paid their rent for a period of time are starting to get evicted. There had also been a moratorium on several student loan repayment requirements that, although the most recent federal legislation continued those, they're going to run out, and there will be students who will unfortunately default on those loans. The new administration has passed some legislation and has been looking at other legislation to try to address the harsh effects of the COVID-19 pandemic on various parts of the population. As we've all seen, the COVID-19 crisis has caused substantial executive and legislative responses from both states and federal government. Each of these require expertise and constant monitoring in the fast-changing environment in which we find ourselves, and I encourage you to find an attorney who is up on those regulations and the application to your business relationships and contracts. Now, the last thing I want to talk about are contracts moving forward. Prior to the pandemic, many attorneys gave little thought to force majeure clauses in contracts. It had been over 100 years since the last major pandemic, and the chance of other acts of God or natural disasters or epidemics were too rare to spend too much time addressing. We are now in a very different position. Several healthcare experts have warned that it is quite likely that we will face another major pandemic in the next few years. As lawyers, we have a duty to protect our clients from the effects of such previously unlikely events. Each contract and each force majeure provision, impossibility provision, frustration of purpose, and assumption of risk provision in contracts will require more consideration and negotiation than they have in the past. Parties with superior bargaining power will either try to shift the risk of unforeseen events to the party with less bargaining power, or at least make the party with less bargaining power pay extra in monetary terms or other terms for such protection. It is important that if you are a client, you have an attorney who knows your business and the effect that a disruption will have on your ability to conduct your business and pay your bills. When preparing for contract negotiations, attorneys and clients need to discuss these matters in much more than a pro forma basis that was done too often prior to COVID. Courts will normally enforce whatever terms the parties to a contract agreed to in their contract, so it's important to be creative and address potential problems, even for unforeseen events, up front. Most courts will not write in a force majeure provision after the fact. So that's pretty much what I had prepared for my presentation. Does anyone have any questions regarding the topics that we've discussed today, or any other related matters? And again, you can type in any questions on the right hand of your screen. All right, I don't see any questions. I'll give it a few more seconds. If you have any questions after this presentation, especially any that may be specific to your business, you're welcome to contact me by either calling me at 703-812-0462 or emailing me at urban@fhhlaw.com. I want to thank you for attending this presentation, and I hope that you are not affected adversely by COVID-19, but I encourage you to make sure in future contracts that we learn from the lessons that we've discussed. Thank you.